My dear students, hope you are all well and safe. Okay, this is your first digital lecture. Now today I will discuss the comparative relation between union and states. The main characteristics of a federal constitution, as you know well, that distribution of powers between the general and the regional governments. According to Professor Ware, one of the great constitutional jurists, that the federal principle means the method of dividing powers so that the general and the regional governments are each within a sphere, coordinate and independent. Our constitution contains an elaborate scheme of distribution of powers, but from the scheme of distribution of powers between the center and the states in our constitution, it appears that the framers have opted for a stronger center. Now, center-state relations are divided into three parts, that is legislative relations, administrative relation and financial relations. Now, so for legislative relations are concerned, the legislative subjects are divided into list 1, that is the union list, list 2, that is the state list, and the concurrent list, that is list 3. At present there are 100 subjects in the union list which are of great national importance, that is subjects such as foreign affairs, defense, railway, postal services, banking, atomic energy, communication, currency, etc. And at present there are 61 subjects in state list which are local importance, that is police, public order, roadways, health, agriculture, local government, drinking water facilities, sanitation, etc. and 52 subjects in concurrent list, and that list includes subjects such as education, forest, protection of wild animals and birds, electricity, labor welfare, criminal law and procedure, civil procedure, population control and family planning, drugs, etc. Under Article 245, the center empowers to give direction to the states in certain cases in regard to the exercise of their executive powers. Under Article 249, the Parliament is empowered to legislate with respect to a matter in the state list in the national interest. And under Article 250, the Parliament becomes empowered to make laws on the matters related to the state list when national emergency under Article 352 is in operation. And also under Article 252, the Parliament is empowered to legislate for 2 or more states by their consent also. So, these are the legislative relation between union and states. Now, come to the administrative relation. Under Article 256 to 263, we find the administrative relation between the center and the states. Under Article 256, the executive power of every state shall be so exercised as to ensure compliance with the laws made by the Parliament and any existing laws which apply in the state, and the executive power of the union shall extend to the giving of such direction to a state as may appear to the government of India to be necessary for that purpose. Now, cooperation between the center and the states. Our constitution lays down various provisions to secure cooperation and coordination between the center and the states, which are firstly under Article 261, the full faith and credit shall be given throughout the territory of India to public acts, records and judicial proceedings of the union and every state. According to Article 262, the Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution and control of the waters of or in any matter any interstate river or river valley. And under Article 263, the President is empowered to establish an interstate council to inquire into and advise upon disputes between states, to investigate and discuss the subjects in which some or all of the states or the union and one or more of the states have a common interest. As per Article 307, Parliament may by law appoint such authority as it considers appropriate for carrying out the purposes of the constitutional provisions related to the interstate freedom of trade and commerce. Now come to center-state relations during emergency. During a national emergency under Article 352, the state government becomes subordinate to the central government. All the executive functions of the state come under the control of the union government. And during the state emergency under Article 356, the President can assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by the governor or authority in the state other than the legislature of the state. During the operation of financial emergency under Article 360, the union may give direction to any state to observe such canons of financial propriety as may be specified in the direction, and to the giving of such other direction as the President may deem necessary and adequate for the purpose. Now come to the financial relations. Constitution deals with the center-state financial relation in Article 268 to 293 and has provided the union government and the state governments with the independent sources of revenue. It allocates the powers to center and the state in the way that is, first of all, that the Parliament has exclusive power to levy taxes on the subjects mentioned in the union list, and state legislature has exclusive power to levy taxes on the subject mentioned in the state list, and both the Parliament and the state legislature are empowered to levy taxes on the subjects mentioned in the concurrent list. The Parliament has exclusive power to levy taxes on the matters related to the residuary subjects also. However, in cases of tax revenue distribution, Article 268 states that the duties are levied by the union but are collected and appropriated by the states. Now come to the important recommendation of the first Administrative Reforms Commission related to the center-state relations. First of all, establishment of an interstate council under Article 263. Decentralization of powers to the states as much as possible, more transfer of financial resources to the states, arrangements of devolution in such a way that the states can fulfill their obligation, advancement of loans to states should be related to as a productive principle, deployment of central armed forces in the states either on their request or otherwise. And during state emergency under Article 356, President's rules can be imposed in event of the failure of constitutional machinery in a state. So what we find that though a federal constitution involves the sovereignty of the units within their respective territorial limits, it is not possible for them to remain in complete isolation from each other, and the very exercise of internal sovereignty by the units require its recognition by and coordinations of other units of the federation. So, federal constitution therefore generally provide certain rules for cooperation which the units are expected to take into consideration while dealing with each other. This coordination between the states and the center is called cooperative federalism. In my next digital content, I will discuss the different doctrines under these center-state relations and also the judicial interpretations. Okay, thank you.